if you're charged with a crime and have a protective order put on you by your significant other, it's really important to understand how these cases can be intertwined in the civil and criminal systems. The first thing that'll happen is when a protective order is filed against you, you have to think about what time the protective order was filed. If it was filed after normal court business hours, an interim protective order will be placed on you. The sheriff's deputies will come to your home. They will order you from the home. You'll have some time to gather up your belongings, and they will then confiscate any firearms that you may own. During the next business hours for court, you'll have what's called a temporary protective order hearing. All right, it'll be in front of a judge, and the judge will make a finding of whether or not it was reasonable that the abuse alleged took place. At that hearing, you do have the option of waiving the temporary hearing and going on with a final protective order hearing. If you do wish to waive the temporary and go forward with the final hearing, you have to understand that the judge, there's a hearing, evidence will be presented, you can testify or not testify, but the judge will make a finding based upon a preponderance of the evidence, which is a much lower standard. It's any bit more than 50% that the judge believes the allegations of the victim, the protective order will be granted. Now, what's important to remember is that if the protective order is filed during normal court hours, a temporary hearing is going to be held, and you are likely not going to have knowledge of that hearing. The sheriffs will come to your house if an order was granted. The temporary order is effective for 1 week, and you'll be called back for a final protective order 1 week from the date of the temporary order. At that hearing, it'll, like just we talked about before, it'll be done preponderance of the evidence standard. Now, what's important to remember is while there is a competing criminal case, if there's an assault charge associated with this, because it's in the civil system, you are not afforded the same constitutional rights against self-incrimination if you were to testify in defending yourself in the protective order. So it's really important to understand that anything you say at that protective order can be used against you later in your criminal case. You're in a courtroom and it's going to be recorded. So the state will have access to anything you say, and you're basically giving testimony without an attorney available, and you're not able to invoke your rights against Fifth Amendment self-incrimination. So it's really important to handle those things with care and really know that what you say can affect the other, and that's what you really have to remember.